took you through.
I agree with the
Yes,
Commissioner.
okay. All right. Thank you.
Thank you, Chair. As I indicated, Mr. O'Sullivan, we're now at your page 17, and we start with the next subtopic, 1.6, General Mkwanazi, Mr. Kistia, and the Louis Vuitton bags. You reference in this part of your statement Annexure R, which is to be found at page 334. That is the article. That is the newspaper article.
Uh-huh.
And just to confirm on this topic, this is all you rely on. This is all the evidence you have about these supposed gifts by Mr. Kistia.
Yes. So,
So then if you may just quickly deal with...
I'm mindful of the time we're spending, so I'll try and be as prompt as I can.
Yes.
And succinct as I can. I had knowledge of this allegation from whenever it was, 2022. And I didn't do anything about it because it's just a media article. But what happened was, after the July 2025 media conference of General Mkwanazi, I started putting bits and pieces together. And one of the things I did was I instructed my attorneys in November 2026 to issue a subpoena to IDAC. And I've evidenced the subpoena as S1 and S2. S1 being the subpoena and S2 being the reply from IDAC. But the important thing for me is if you look at page 18, the reply to the subpoena sought to obtain evidence of these so-called Louis Vuitton bags. And the reply I got from IDAC to my lawyers was, quote unquote, "These are criminal matters that remain active, and IDAC cannot share any of the information and or documentation requested in paragraphs 1 to 4 of the subpoena." That's all the evidence I have. So it's not a smoking gun. You've got a newspaper article, an attempt by me to validate the newspaper article by issuing a subpoena, and IDAC's response saying, "This is a live investigation. I'm not giving you an answer to your subpoena." And commissioners, I'm saying, surely that gives the impression that there is something here. There's something going on with these Louis Vuitton bags.
Mr. Sullivan, can I ask you this question? In paragraph 1.6.2, you say this gentleman is alleged to have gifted. Do you know who makes these allegations? Do you know who the source of the allegation?
Say again, I didn't catch you.
Paragraph 1.6.2 on page 17 of your statement.
Yep.
The name of the gentleman is mentioned there, and
Mr.
you say,
Kistia.
yes, it is he's alleged to have gifted expensive
It's what's
bags.
in the article.
So you're relying on the article?
I'm relying on the article, and that's why I'm saying this is from the article. Mr. Kistia is alleged to have gifted these Louis Vuitton bags.
But you don't know who makes the allegations. You don't know who the source is.
Commissioner, if you look at the article, it doesn't give a name.
No, I'm asking you, Mr. Sullivan, forget about the article. I'm asking you sitting here today. Do you know who makes the allegations, or who is the source that makes the allegations?
My understanding, and I put it to you in my statement, is that it was Brigadier Russ, a female brigadier who went on the journey with them. And that's on page 18.
Where he references annexures S1 and S2, Commissioner.
Yeah. So my understanding is that Brigadier Russ was also given a Louis Vuitton bag, but when she returned to South Africa, she handed it in because she said she didn't want it, because she knew that Inbanath and Kistia either was going to be charged, or she knew that there was a corrupt relationship. Inbanath and Kistia is currently on trial with General Pashlani for corruption involving vast sums of money, millions and millions.
I just wanted to make sure that you are not attributing to her things she did not say.
Yeah. Sorry?
Did she say that? Or is that what you assume she said?
I received information that she was on that trip and she handed the bag in. I've never spoken to her.
Okay.
Okay?
Sorry, Mr. O'Sullivan. I'm looking at what Commissioner Khumalo just referred you to in paragraph 1.6.2.
1 point?
Where Commissioner Khumalo just referred you to, 1.6.2, the part that says, however, I was able to later confirm the allegations from a source. It seems a female brigadier, that's the brigadier you referred to. I think you gave a name just now, or not?
Correct.
Yes.
It's on the next page.
Yes. The brigadier was on the trip to Europe and also received a bag which she then handed to IDEC. I'm comparing that with what appears in the article that you say is your basis
That
for...
doesn't appear here.
Yeah, because at page 335, here's what the article says, the third paragraph at 335. I'm reading the last sentence. The two, that is General Masemula and General Mkwanazi.
So which paragraph?
The third paragraph at page 335.
Yes.
I'm reading the second sentence, which is the last sentence of that paragraph. It says the two returned home with luxurious bags, while their colleague, I assume the colleague is the brigadier, or not?
So, Commissioner, in my opinion, this story is possibly slightly wrong, because my understanding is that the person that was snubbed wasn't snubbed, but also got a Louis Vuitton bag and brought it back to South Africa and handed it in with a sworn statement.
Also, that part of the article is wrong.
Pardon?
So that part of the article is wrong.
Yes.
Oh, all right. I just wanted to check that because you
That's
basically...
my understanding,
Yeah.
Commissioner. Yeah.
Can I just clarify from your response, the question and response by Commissioner Khumalo, and your reference to that Brigadier Russ, your statement as it reads, it does not say she reported General Masemula and Mkwanazi.
It
Is that
says on paragraph 1.6.2, Commissioner, it says, however, I was able to later confirm the allegations from a source.
Yes.
It seems a female brigadier was on the trip to Europe and also received the bag, which she then handed to IDAC.
Yes, but that doesn't say she reported the two generals that they received a bag.
Yeah, I could have said together with a sworn statement, but my understanding is there was also a sworn statement.
Is your evidence that the brigadier submitted a sworn statement in which she states?
My understanding, so...
Yeah, let me finish for the record. Yeah. I do need to finish. My question is, and I just seek to clarify what you are saying. Is your evidence that Brigadier Russ, who you say also received a Louis Vuitton bag, she declared it to IDEC, or she reported it to IDEC, and she submitted a sworn statement. Are you saying in that sworn statement, she also states that the two generals, Masemula and Mkwanazi, also received Louis Vuitton bags? Is that what you're saying?
I wish I knew, Commissioner, but when I served the subpoena, this is what I sought clarity on.
Okay, so you haven't seen her statement?
No, I haven't seen it. If I'd seen it, you'd be seeing it now too.
Okay.
Because I wouldn't keep information from you. So to be crystal clear, this, you could say, is just pure hearsay. However, it would be hearsay if I'd have got a feedback from my subpoena that said, listen, I don't know what you're talking about, get lost. That's not what I got. What I
Yes.
got back was, these are criminal matters that remain active, and IDAC cannot share any of the information or documentation requested in paragraphs 1 to 4 of the subpoena. And that tells me there's something going on here. And what I also noticed, and I mentioned it in my statement, is that nowhere in the evidence that he gave, either at the ad hoc committee or at this committee, General Nku specifically state, by the way, for the record, I've never received a Louis Vuitton bag. Instead, he makes throwaway comments such as, at least my wife now knows what a Louis Vuitton bag is valued at.
Okay, I haven't seen his evidence in the ad hoc committee. He will come back. He will come back to us and he'll speak to that. I just needed to clarify what I thought I had understood your evidence to be. Thank you.
And your,
thank-
and your source about the brigadier, was that a sub-source or not? I'm not asking for a name.
Yes, it was a SEP source.
Thank you.
Thank you, Commissioners. Mr. O'Sullivan, if we go to, you make the point at paragraph 1.6.3 regarding IDEC's response to your subpoena.
Correct.
And you suggest that their response and the manner in which it's couched, as you quote there, is what gives either credence to an allegation that there's something, what did you say? They smoke.
Yes.
I think, yeah. But I accept that. I would like us to look at your annexure R. And that is the article at page 334. At page 334, the last paragraph on that page, the article reads, and I quote, in a case that resembles that of former top cop Jackie Silebi over a decade ago, Masemola and another former National Commissioner Mkwanazi were last week slapped with subpoenas by the investigating Directorate ID to explain why they failed to declare Louis Vuitton handbags they received from controversial Durban businessman and sub-supplier in Banatan Kistia. Apologize if I mispronounced that. So that's what the article claims, that they were served with subpoenas. So would you accept, if the article is correct in that regard, IDEC's response would also be correct in saying that these are criminal matters that remain active in IDEC, if IDEC had issued a subpoena and
thank you.
conducting an investigation?
If you look at page 338
Yes,
of my evidence bundle,
yes.
it's that page of the subpoena. It's listing 4 items. 1, all ID/IDAC communications and or subpoenas sent or served on Lieutenant General Nku and or General Fani Masemola, asking them to, so this subpoena is based on that article. It's asking for this clarity. It's asking for any response received from IDAC. It's asking for a photograph certified as a photo of the Louis Vuitton bag currently in the evidence locker or evidence room of ID/IDAC. And finally, a certified copy of the sworn statement provided to ID/IDAC by the brigadier that attended on the overseas trip with General Nku and General Fani Masemola, in which she explains the receipt of the Louis Vuitton bag mentioned in 3 above. So the response tends to confirm inadvertently those issues.
But I'm not taking issue with that. I accept, and I say if we accept the correctness of the article, that IDEC issued subpoenas in respect of these bags.
It would appear to be the case.
Yes, and if we accept that that is potentially the case, then the response by IDEC has got to be appropriate, that these are part of ongoing investigations,
Yes.
and they are not in a position to share
Correct.
the requested information with you.
Correct. Which is why I decided to raise it at the commission.
And it does, IDEC's response doesn't imply that the investigations have established as a fact. It simply mentions that the investigations are ongoing.
Correct.
Okay, thank you. And you have testified to the fact that General Mkwanazi's response is what you believe further lends credence to the claim, where you quote him as saying, "At least my wife now knows what a Louis Vuitton bag is valued at." Mm-hmm. And that's the sum total on which, that's all you can
The
put
point I
forward.
was
at this
making,
point, yeah.
Commissioners, is that nowhere could I see him saying, by the way, for the record, I never received any Louis Vuitton bag. Instead, he gives this throwaway comment, "At least my wife now knows what a Louis Vuitton bag is worth."
Is there anything else on that subtopic that you would like us to?
Nothing at all.
Okay, then staying still at page 18, that leads us to the next subtopic at 1.7, General Mkwanazi, political pressure, and Lieutenant General Mdluli. Now, this is quite a old subtopic. You start at paragraph 1.7.2 by summarizing Annexure T, which is the affidavit at page 336, which is the affidavit. I think my numbering is, no, not 336. I'll find the correct page for you.
345.
345, page
Yep.
345. Thank you. Now you summarize this affidavit in detail over the next couple of pages.
Over the next 4 pages.
Over the next 4 pages, and you contrast that with the papers from the Freedom Under Law application
Yes.
that was launched
Yes.
to review and overturn General Mdluli's reinstatement following his suspension, correct?
Yes.
Can we try and summarize what the key issues arising from these two
Yes. And if I,
substantive documents are?
my summary,
Just a moment.
Sorry.
Can I ask that because you're going to summarize that we amend paragraph 1.7.2.11? So
Instead
on
of
page
22.
21, that 15 May should be 2012 and not 2021. 1.7.2.11 on page 21.
yes.
Are you there?
Yes, I'm there, yeah.
That 15 May date should be 2012, not 2021.
Yes.
Correct. Thank
Well
you,
spotted.
Commissioner.
Thank you.
Thank you. You may proceed, Mr. O'Sullivan.
Okay, thank you. First, I should thank the Commissioner. You know, this was typed very late at night. The essence of this can be found at paragraph 1.7.1.
If I may, I do beg your pardon.
Pardon?
I do beg your pardon for interrupting. Just to point out that your Annexure T, that affidavit, General Mkwanazi has already submitted before the commission when he testified in September. Then commissioners, for the record, is MK22. So we have dealt with that affidavit before, and maybe in a slightly more cursory fashion. So it's not new to the commissioners, this affidavit.
Okay.
They've seen it before. Thanks.
So if I can take the Commissioners to page 18 of my statement, in particular paragraph 1.7.1. So in order to go forward, we have to go back a little bit. And what I'm saying here, if we go back to the media conference of the 6th of July, 2025, there were 2 central themes of General Mkwanazi's press conference. The one was organized crime's infiltration of the criminal justice system, and the other was political interference in the police by the Minister of Police. Those were the 2 central themes, and I think that's common cause. I've dealt with, in some detail, the examples of infiltration of the underworld into the police and the effect that has had on the police. And I've said it wasn't new. And I'm making the point here by saying, nor was political interference in the SAPS new. The irony of the latter fact is that during his period as acting National Commissioner in 2012, General Mkhwanazi himself turned a blind eye to unlawful political interference relating to the then Divisional Commissioner of Crime Intelligence, Lieutenant General Richard Ndluli. In fact, General Mkhwanazi not only turned a blind eye, but he also acquiesced to patently unlawful instructions, then later helped to cover it up. And that may be considered a very serious allegation. But the evidence I will present will actually bear out this allegation, Commissioners. And first of all, we start with this paragraph 1.7.2, which rambles on. And what it is, it's an analysis of Annexure T. And Annexure T is the self-same affidavit presented by General Mkhwanazi to the State Capture Commission, and it's dated 29th of September 2020. Now, in that affidavit, he makes certain averments under oath. And what I've tried to do here is to capture those averments. In other words, to coin a phrase, explain what it is he was saying under oath. And I want, rather than read out every single one of those sub-paragraphs, I want to jump forward to page 20 of my affidavit and go to sub-paragraph 1.7.2.8. And the last four lines of that sub-paragraph states, quote, "Finally, under pressure from the Minister of Police at a meeting to which he called the Inspector General and General Mkhwanazi, the Inspector General," this would be the Inspector General of Intelligence, Commissioners, "the Inspector General reinstated the opinion and recommendation. I cannot think of a more blatant demonstration of unlawful executive overreach." It's me saying that. And then I go on to 1.7.2.9. At the meeting with Minister Mtetwa, and this is based on his affidavit, at the meeting with Minister Mtetwa and the Inspector General of Intelligence, the Minister instructed General Mkhwanazi to uplift the suspension of General Ndluli. General Mkhwanazi later claims to have informed Minister Mtetwa at the meeting that his instruction was illegal. Nevertheless, he acquiesced. General Mkhwanazi has always been deliberately vague about the dates and times of these meetings. Given the importance of same, there can be no legitimate reason for this vagueness. And then we continue on page 21. 1.7.2.10. Following the meeting with the Minister of Police and the unlawful reinstatement of the Inspector General's opinion, bearing in mind, according to his version of events, the Inspector General of Intelligence was like a straw in the wind, flip-flopping, 1 minute saying this and the next minute saying that, and then going back to the original. It says here, General Mkhwanazi uplifted the suspension of General Ndluli on the 27th of March 2012, and he returned to work, where he was also handed the additional responsibility of protecting the President and ministers. So this whole division in the police called the Security Division of the Police, which is the VIP protection units, was now suddenly handed over to the divisional head of crime intelligence, which is Richard Mdluli. And then on the 15th of May, 2012, thank you, Commissioner, for pointing out the 1 and 2 being the wrong way round. After the Freedom Under Law application was launched, new disciplinary proceedings were instituted against General Mdluli, and on the 25th of May 2012, General Mkhwanazi recanted his earlier decision and suspended General Mdluli again. Public pressure was building. At the start of June, General Mkhwanazi met with President Zuma and appears to have been pressurized to withdraw the new disciplinary proceedings against General Mdluli and his suspension. This is based on his version of events. At the meeting, it was agreed that General Mkhwanazi would not continue as acting national commissioner beyond the few remaining weeks that were required to appoint a new national commissioner, General Pieko, with zero policing experience, that's just my throwaway, was duly appointed on the 12th of June. So now suddenly, General Mkhwanazi, who's been the acting Commissioner of Police since the prior year in September, is now suddenly no longer the acting Commissioner of Police. And then I go on to page 22 at 1.7.3. I say, on its own terms, the narrative of General Mkhwanazi shows that he readily succumbed to political pressure and implemented the illegal instruction of the minister to uplift the suspension of General Mdluli, whilst all material times knowing that this instruction was illegal. How do we know, commissioners, that at all material times he knew the instruction was illegal? Because he says so under oath in 2020. But here's the best part. When he enacted this unlawful instruction in 2012, he was invited to Parliament. And on the 19th of April, he was asked at Parliament why he had uplifted the suspension of General Mdluli and put him back to work. And his answer was short and sweet. He said, I acted according to higher authority. And when he was asked what the higher authority was, he declined to say. On the 15th of May, when the Freedom of Under Law application was launched, there were two sections to it, a Part A for urgent relief and a Part B, which was a confirmatory of the urgent relief. And the urgent relief that Freedom Under Law requested, and I've got all the pleadings, the urgent relief that Freedom Under Law requested was that the decision of General Mkhwanazi was to be declared unlawful and invalid, and that General Mdluli was to be put back on suspension and removed from doing his police work. Now, that Part A application was launched on the 15th of June. It was an urgent application. General Mkhwanazi supplied the answering affidavit. And in the answering affidavit, he doesn't deny that he was acting on a higher authority. In fact, he keeps quiet about it. He keeps quiet about it for 8 years and only comes out with it in 2020. So from 2012 to 2020, nobody in the country knew that he had acted on the unlawful instruction of the then Minister of Police, Nathi Mthethwa. And that is the point I'm making here. So then I say at 1.7.4 on page 22, when regard is had to the facts of the Freedom Under Law application, General Mkhwanazi's collusion with the illegal interference of the Minister and the President is even more stark. The chronology of the Freedom Under Law matter is the following, and I set out the chronology. And at 1.7.5, I say the following. There are two noticeable aspects of General Mkhwanazi's conduct in relation to the Freedom Under Law litigation that show he assisted to cover up the executive interference in the SAPs, which he knew to be unlawful. 1.7.5.2. First, in the face of the founding affidavit from Freedom Under Law that specifically alleged executive interference in an attempt to pressurize him to withdraw the disciplinary action against General Mdluli and his suspension, General Mkhwanazi did not admit the relevant facts. Instead, he deposed to an affidavit which did not respond to the allegations, but nevertheless opposed, on spurious grounds, the urgent interdict sought to prevent General Mdluli from executing police functions. And this is found at page, the evidence here, Commissioner, I refer to paragraph 49 of the Supreme Court of Appeal judgment and paragraph 211 of the High Court judgment. Now, if you go to page 437 of the evidence bundle, you will see that I have highlighted a number of paragraphs because it's quite a lengthy judgment. But if you look at page 437 at paragraph 211, this is now the full application. So what you had was a part A and a part B. And the part A was heard by Justice Makhoba J. Expressed, and it says here in paragraph 14 of the judgment in the part A proceedings, Makhoba J expressed concern about the allegations of political interference in the disciplinary process and noted that Mkhwanazi had not disputed them in his answering affidavit. Now, if you go back to page, or go forward to page 469, which is in the Supreme Court of Appeal, page 469 at paragraph 49. This is now the Supreme Court of Appeal judgment. At paragraph 49, Commissioners, it states, as a factual basis for the challenge of these decisions, Freedom Under Law relied in its founding affidavit on a statement by the then acting commissioner, Lieutenant General Mkhwanazi, in Parliament that he was instructed by authorities, quote unquote, beyond him to withdraw disciplinary charges and reinstate Mdluli in his office. Freedom Under Law added that in doing so, Mkhwanazi had failed to make an independent decision, which rendered his actions reviewable. Though Mkhwanazi filed an answering affidavit in the interim interdict proceedings in Part A of the Notice of Motion, he did not deal with these allegations. So you had this situation where General Mkhwanazi is facing litigation based on his conduct to unlawfully act on the instructions of the Minister of Police. And what's the relevance of all this, you may ask? Well, his complaint on the 6th of July last year had two legs to it. One was criminal interference or penetration of the police, and the second leg was the executive overreach, the ministerial interference in the management of the police, which is exactly what happened in 2012, and he was a party to it, and not only was he a party to it, he helped cover it up for the better part of 8 years. And only in 2020 does he come out with it.
Yes. Mr. O'Sullivan, I'm just trying to understand the import of your evidence. Are you saying because of what you describe as his past conduct, are you saying he should not have spoken up in July? He should not have complained about political interference?
Commissioner, what I'm saying is you can't change history. He did what he did.
Yes.
What he didn't do when he came to this commission, he didn't take the commission into his confidence and say, by the way, although I'm speaking out about it now, I just want to inform you that 14 years ago, I was engaged in just the same activity.
So is the criticism, I'm trying to understand, as I say, the import. What are we to do with this evidence that you obviously consider to be important to mention, are you saying because according to you, he was complicit, and at this point, I'm not dealing with whether or not what you're saying he did previously is correct. I'm asking if you're criticizing, as I understand, and please correct me, if you're I understand you to be criticizing him for, on the 6th of July, mentioning or complaining about overreach, political overreach or political interference. I understand you to be criticizing him for that. And I'm trying to understand, are you saying with that criticism, are you saying he should not have spoken as he did about this aspect of things? This second, you say there are two legs to it.
Well, it's hard to come to a informed answer there, other than to say that was I not to produce this evidence here now, this commission would be completely unaware of the fact that the conduct he's now complaining of was exactly the conduct that he was involved in some years back. And if you're going to be a whistleblower, as he claims to be, you should be a whistleblower with clean hands.
Yeah, exactly my confusion. That's why I'm asking you this question, exactly my confusion. Are you saying he is not a clean whistleblower, according to you, because he previously colluded in similar conduct? Therefore, he should not have spoken up. Is that the heart of what you're saying? And maybe let me suggest to you that I ask the question because it's quite conceivable that someone thinks about it this way. The man had a Damascus moment. He previously colluded, according to you, and then come July 2025, he decides not anymore, and he changes his mind. I'm asking from that perspective, are you saying he should have kept quiet forever?
Yeah.
Or the other possibilities you're saying, well, because he's got this past conduct, we should disregard his complaint of 2025 and disregard it to the end that he's talking, sorry, I can't think of a better word, he's talking nonsense. There was no political interference in 2025. Is that the point you're making?
So my understanding, Commissioner, and you might have to interrogate me a bit further, but my understanding is quite simply this. If you're going to have a Damascus moment, put that down in writing. Say, look here, by the way, I'm speaking out now because I saw what happened all these years ago. And I was involved, but he didn't do that. He's kept quiet.
Yeah.
And therefore, I think it would have been better, rather than speak out at a media conference, to take action without drawing down the public confidence in the criminal justice system, because it's been shattering what's happened in the criminal justice system.
Okay, I guess I've asked my question and you've answered the way you did. I'll accept that's your best answer. The second issue about it, you've referred us to these judgments, and let's start with at 437, page 437, which is Makhoba J's judgment. Are you saying by not, because remember you've highlighted the part and you've read out where the judge says in his answering affidavit.
Sorry, ma'am, if I can just ask the paragraph number?
Looking at page 437.
Yeah, 437.
And then I'm looking, you referred to paragraph 211.
Uh-huh.
And you read there where the judge says, Mkhwanazi had not disputed, maybe let me start at the beginning. It says in paragraph 14 of his judgment, Makhoba J, well, I think this is the SCA judgment, in fact, you're referring to. Makhoba J expressed concern about the allegations of political interference in the disciplinary process and noted that Mkhwanazi had not disputed them in his answering affidavit. What are you saying there about the conduct of General Mkhwanazi?
What I'm saying here, Commissioner, it's not me saying it, it's the High Court. And it's a scathing judgment against, this is what's referred to as the Murphy judgment. And it's a scathing judgment against the police.
Yes.
And against, in particular, General Pieka and General Mkunazi, against both of them. And this judgment hasn't seen the light of day for probably 10 years or more.
Yes. I'm asking the simple question because, another construction, and I think in our practice-specific allegation, you have admitted it. So when I read 211, I would have concluded, until you spoke, I would have concluded, well, it means he didn't dispute it. He didn't dispute that there was political interference. But you seem to be reading that paragraph or to be attaching a meaning to it, that he basically was part of the cover-up, unless by not responding or not denying the allegation of ministerial interference, he therefore covered up, unless I misunderstand you, Mr. O'Sullivan.
Commissioner, you have to look at all the bits that I've highlighted and take them together. But if I go to page 438.
Yes.
Paragraph 215, 216, and 217 and 218.
Yes.
This is scathing. It says Mkunazi dropped the disciplinary charges on orders from above is furthermore borne out by the Rule 53 record filed on his behalf. The record he supplied comprises nothing more than 2 letters addressed to Ndluli, one notifying him of the withdrawal of the disciplinary charges against him and the other advising him of his reinstatement to work. It doesn't say to work. There's no charge sheet or correspondence dealing with blah, 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 and it goes on. And then 216, it says, the inescapable finding is that the decision of the acting commissioner to withdraw the disciplinary charges and to reinstate Ndluli as head of crime intelligence were taken in an attitude of subservience pursuant to an unlawful dictation from a person unknown.
Yes.
Who was beyond the acting commissioner. By the way, at this stage, nobody would admit who it was that gave him the instruction. That only came 8 years later. Yes. He says, an abdication of power violates the principle that the responsibility for discretionary power rests with the authorized body and no one else. And
yes.
It goes on to say at 218, to ensure the proper function of the SAPS, the Commissioner, in discharging his obligations under Section 11 of the SAPS Act, must protect and give effect to SAPS discipline regulations. It's a scathing judgment. And the failure, it's not the judgment that's more important, Commissioners. What's more important to the people of this country is that this has been kept hidden. It's been kept under wraps. It should have been part of the evidence. He said, by the way, the reason I did what I did on the 6th of July is because 14 years ago, I was involved in exactly the same state of affairs, and I went along with it and covered it up for 8 years.
I guess, Mr. O'Sullivan, my question is, what difference does it make? Remember, we consider our terms of reference. I don't know that we can take it any further, but really my question is, even if you are correct in your position that when he testified here, he should have confessed his previous sin of covering up, as you say.
Yes.
I'm still left with the question, okay, what difference does it make to, he has spoken up. We are investigating exactly that as a commission, whether indeed there's been political interference. Does it really make a difference that, and if so, what difference does it make to how we deal with that allegation of his? That when he sat there and testified, he didn't testify to his previous crime of colluding in the similar decision making that he's now complaining about.
Well, except Commissioner, it's my evidence that not only was he previously involved in that conduct, but for 8 years he covered it up. For 8 whole years. And it only came out when he made his statement at the Zondo Commission. And when he made his statement at the Zondo Commission, he did not go into the nitty-gritty of what actually took place. He gave a version of events, and I obviously have no first-hand knowledge as to whether or not the then Minister of Police in 2024 or 2025 did engage in executive overreach. I have no knowledge of that. It's not something I've been involved in. But if a person is going to become a whistleblower, surely that whistleblower is going to say, by the way, the reason I'm whistleblowing is because I was involved in this conduct 14 years ago and I saw the effect of it.
Thank you.
Thank you.
Thank you, Commissioner Baloyi. If I understand your summaries of both General Mkwanazi's affidavit before the Zondo Commission and the freedom under law application, that application was brought in 2 parts, the interim relief in Part A and the main relief, the review in Part B. General Mkwanazi deposed to the affidavit in Part A, and I think you make the point in your statement that by the time Part B came around, General Pierre was deposing to that affidavit. So when you charge General Mkwanazi of failure to disclose, that he would be required to do in Part B, when by then he had already been transferred or to another department and General Pierre had taken his position. Do I understand you correctly?
Then I would point the commissioners at page 25, paragraph 1.7.9
Yes.
and 1.7.10, which I would like to read out.
Okay.
This is my testimony. Accordingly, even after he was fully aware of the contents of General Pieka's affidavits in the freedom under law proceedings, General Mkwanazi continued to cover up the illegal instruction he'd been given by Minister Ntetwa and the political interference of both Minister Ntetwa and President Zuma in decisions that he ought to have been able to take, free of any political interference. He could have, at that time, and indeed should have, approached the court with the truth. He failed to do so. He only finally came partly clean when he was interviewed by the investigators at the State Capture Commission, led by Justice Zondo. Even then, his version was a cover-up of the truth, and he fobbed them off by blaming others. Given General Mkwanazi's own collusion in an illegal process of political interference designed to keep General Mdluli in charge of the Division of Crime Intelligence and its regularly stolen secret funds, it is difficult to take seriously his complaints of political interference that he made in his infamous speech on the 6th of July 2025. In fact, General Mkwanazi's own unlawful conduct in 2011/12 make the current complaint he has made pale into insignificance while still sharing commonalities. For example, in 2011-12, General Mkwanazi's conduct was intended to unlawfully protect Crime Intelligence Divisional Head, much the same as his conduct in 2025 is intended to protect the Crime Intelligence Divisional Head and those under him.
If I just take a step back to your paragraph 1.7.9, just to clarify something.
Sorry, just catch that paragraph.
Page 25, paragraph 1.7.9. You state, and this is in response to the point I had raised with you, that the answering affidavit in the review application was deposed to by General Piecha, who had assumed that position by then.
Correct.
You state that even after he, General Mkhwanazi, was fully aware of the contents of General Piecha's affidavits and the full proceedings, General Mkhwanazi continued to cover up the illegal instruction he had been given by Minister Mthethwa.
Correct.
Now, what form did this cover up take? On what basis do you say he continued? Firstly, he covered up, and secondly, that he continued to cover up. Thank you.
Maintaining silence. Because what happened, commissioners, while that period between Richard Ndluli being suspended and then having a suspension uplifted and then having a suspension reinstated and the court case is going on, during that period, the whole thing was argued out in court. And when it was argued out in court, it was all over the media. And the Supreme Court of Appeal go into some detail about how General Piecha misled the High Court. And General Mkhwanazi kept quiet. He had a duty. He could not ignore that duty. And that duty was to step forward and say, well, hang on a minute. Actually, General Piecha's version of events is not true.
Was he a party to this application?
I'm saying he was. And the reason I say he was is contained within Annexure W.
And Annexure W,
Annexure W.
page 475, that's where it starts.
Yes. If you have a look at page 14 of Annexure W, which is page, just bear with me a second. I'm going to have to count the pages.
If you perhaps give a sense of what you are looking for, we might try and assist.
14. Aha. Here we go. It's page 488 of the evidence bundle.
488.
488 of the evidence bundle.
Thank you.
So this is a presentation that was made on the 13th of November 2015 by the Minister of Police.
Yes.
It was, in fact, Mr. Nhleko was the Minister of Police then. This was a presentation by the Minister of Police to Parliament. And it's been uplifted from the parliamentary monitoring group thing. So this was made on the 15th of November, 13th of November.
It speaks of a grievance. It doesn't speak anything about, it's not answering
No,
my
but what it's
question.
showing, Commissioner, is that Lieutenant General Mkhwanazi lodged a grievance against the National Commissioner for lodging false affidavits in court regarding Lieutenant General Ndluli's case. And the point I'm trying to make is this corroborates the fact that other than lodging a grievance, he did nothing about it. He allowed her to lie to the court.
But that grievance has a finding as well further on in the, say, on the same page. The first point speaks to the grievance lodged by General Mkhwanazi. Then there is a finding.
Yep.
And the finding says the
Finally says the National Commissioner informed the court wrongly with regard to Lieutenant General Mkhwanazi's actions on Ndluli matter. So what she actually did, what General Piecha did, was she informed the court, and that's borne out in the judgment. She wrongly informed the court that General Mkhwanazi had not received instructions from a higher authority. She said that was a misunderstanding, and I'm going to supply a confirmatory affidavit from General Mkhwanazi. It was never supplied. There was no, and even when it went to the Supreme Court of Appeal, they still couldn't supply a confirmatory affidavit. So the whole thing was hushed up. And what I'm saying, commissioners, is if there was going to be any transparency here, it should have been a sworn affidavit by General Mkhwanazi informing the court and opening a docket against General Pieka for lying to the court, which in effect, apart from being perjury, is the offence of defeating the ends of justice. And no such event ever took place.
I think my point is he wasn't a party to these proceedings, so he didn't have standing to file any affidavit. That's
He
my
wasn't a
point.
party, but he knew what was going
Yeah,
on.
but he wasn't a party. My question was he a party? And you said yes, and you referred us to this
He
document.
was a party to the original proceedings,
Yes.
the Part A.
Where you are saying he should have filed an affidavit. I'm saying he wasn't a party to those proceedings where now General Pieka is the party that is being sued. So he wasn't a party. You understand what I'm saying?
I understand.
Yes. I think that's the first point. The second point, in the judgment, in the Murphy judgment, and this I think we accept it was in 2012. I think it was in 2013.
Say again?
In 2013, that's the Murphy judgment, right?
Yes, yes.
And it states at I'll read it for you.
What's the
it's
page number?
Page 436. And this is about the point of you saying he didn't speak up for a whole 28 years, I think you say, and spoke up for the first time in 2020 before the so-called Zondo Commission. And I'm reading this just to say it seems to suggest differently from what you're saying. At page 436, paragraph 207, it says, in paragraph 45 of the founding affidavit, FUL alleged that the acting commissioner publicly stated in Parliament that he took the decision to withdraw the disciplinary charges on instructions from authorities beyond him. And then Full added that by acting on the instructions of authorities beyond him, the acting commissioner failed to act independently. So it seems that at least Full, FUL, was aware when they filed their papers that he has spoken publicly, that
In fact-
the decision, let me finish,
Yeah, sorry.
that the decision that he took was imposed on him from higher authority. So why do you say that he kept this quiet until only in 2020?
Because at the parliamentary committee, it was asked what higher authority. He couldn't answer. He should have said the Minister of Police instructed me. Instead, he covered the thing up.
So the criticism is he didn't state it's the
Didn't state-
minister.
In fact, what happened, if you look at General Pieka's conduct in the FUL response, she said that actually what he said at Parliament wasn't correct.
Yes.
He made a mistake. What he actually meant was the NPA had decided to withdraw the charges, and that's why he followed suit. The whole thing was a complete lie.
Okay. So that's Pieka. For now, I was just clarifying.
Yes.
I was clarifying that when the FUL prepared his answering affidavit,
Yes.
General Mkhwanazi had already said in Parliament that he made the decision on higher authority, or it was dictated by higher authority. And your criticism, and I hear you.
They couldn't get it out of him.
Your
Parliament
criticism is he didn't say the higher authority is the minister.
That's what he
your
should have said.
Okay, thank you. Thanks, Mr.
Thank you.
Just one issue with you, Mr. Sullivan. Going back to page 488.
Page?
488. Remember, throughout this section of your affidavit, the point you sought to make was that General Mkhwanazi has kept quiet for 8 years about the political interference that took place when he was acting national commissioner. Doesn't that paragraph in 1, the bullet point that sets out the grievance that he lodged in 2015, undermine that argument because it shows that as far back as 2015, he spoke about the fact that General Pierre misled the court in relation to the Mdluli matter. And then it ties up with what Commissioner Baloyi says, that even prior to that, he had said in Parliament that there was interference. Although he did not say who interfered, but at the very least, he did say there was interference.
I hear you, Commissioner.
So you cannot then in those circumstances say for 8 years, he did not say anything, because what this presentation at least shows is that when he became aware that General Pierre may have misled the court, he lodged a grievance against her on the very Mdluli matter, so on the subject of the very issue that we are discussing. The detail may not have been there, and because you were not part of the presentation, maybe you would have expected more detail, but it's not correct to say there was complete silence for 8 years. That's the point I'm trying to make with you. That at the very least, there was something, not the detail that you expected.
There was something, Commissioner, but there wasn't transparency. What there was a complaint against Pieka for not telling the truth. But there wasn't, by the way, she wasn't truthful. What she should have said was bang, bang, bang.
Yeah.
He didn't do that.
But he goes a step further and he says he was not even consulted when the affidavits were prepared. The point being that if he was consulted, he would have stated the true facts.
Well, except for the fact that when he made the first affidavit in the Part A, he kept quiet about the matter. If you look at the pleadings on the FUL matter, on the freedom under law matter, they make it crystal clear that their pleadings, their application is based on the statement he made in Parliament on the 19th of April, where he stated to Parliament, when they said to him, why have you put this man back to job? Why have you lifted the charges against him? He said, I've acted on the basis of a higher authority. And they asked who? He refused to tell them. He couldn't tell them. So I'm saying he covered it up all the way along. And what that cover up comprised of, yes, you can say that this complaint, which was a grievance, there should have been a sworn affidavit stating the chapter and verse. It only came out in 2020. And please listen to this very carefully. What he stated to the Zondo Commission in 2020 was not chapter and verse. What he should have done was given a blow by blow, where the meetings took place, when they took place, the dates and times and everything. He didn't. The thing was kept vague. And I'm saying it was deliberately kept vague.
But in the affidavit before the Zondo Commission, he does mention the days of the meetings. If you go to 376, 376
Yeah.
and that's the affidavit before the Zondo Commission.
Correct.
You will see that he mentions the meetings, he mentions the date.
Paragraph number, sorry?
The dates of the letters.
Yes, that's referring to dates of letters.
Yes.
But the information that's missing, Commissioner, is the dates of the meeting. Respect of the police minister. That meeting date has been kept vague. There's no date there.
Yes. But we know that it is March because the letters are the March letters. So when he refers to the IG opinion that was first issued and then was later withdrawn, so he's referring to the March date, and that much is clear from paragraph 48 on page 356, that we are in the March period because we know that the meeting with President Zuma happens in June. So although it doesn't specify the date of the meeting, but it's quite clear that the date is between the
somewhere around then.
It's between the two opinions by the Inspector General. So
yeah.
It would have been between the 6th of March and the 19th of March. That's at least how I read paragraph 48, that the meeting would have happened between those 2 dates.
Commissioner Khumalo, perhaps what might assist is reference to page 363.
Yes.
At the bottom of 363 is paragraph 39. That gives the date on 23rd April 2012, Lieutenant Drummond authored a further letter. This is in the sequence when he's narrating sequence of events.
Sorry, page?
It's paragraph 39.
Sorry, what page number?
I'm sorry, I was looking at the wrong version of the document, but it's paragraph 39.
372.
If you go then from 372, paragraph 39, that's where he introduces the date, the letter by Lieutenant General Drummond of 23rd April 2012. And then at 40, he quotes that letter. And then at paragraph 42 under heading H, interference by Minister of Police. It says, a few days after my conversation with Advocate Khadebe, I chaired this meeting at the police headquarters, and he continues. So if one were to follow his timelines, it would give you a good sense of when the meeting, although admittedly it's not dated, took place. Would you have a challenge, a difficulty with that?
Commissioners, the only difficulty I have with that is that if it's such an important meeting, why don't we have a date for the meeting and a time for the meeting that says on this day at this time, the following meeting took place? I'm just saying that's the way I see it.
Okay.
It could well be that he's happy with keeping it vague. I'm not happy with keeping it vague.
That's why I was saying your issue is not so much that he did not disclose what happened. Your issue is that he did not give the full detail, including the date.
Yeah. When he disclosed it on the 2020 affidavit, in the 8 years preceding that, he had an opportunity to come out and say, by the way, on this date, at this time, I had a meeting with the Minister of Police, who unlawfully instructed me. The only time this comes out is here, 8 years later. It never came out before then. Never. Thank you.
On that score, then, may I invite us to go to your page 23 of your statement?
Page?
Page 23.
22.
23.
Uh-huh.
And paragraph 1.7.5.3, you actually make a much stronger allegation against General Mkhwanazi. You say, second, he appears to have colluded in allowing subs to put a dishonest version in their answering affidavit to Part B to the court. Yeah. When then Commissioner Pierre falsely stated that there had been no instruction to General Mkhwanazi from above.
Yeah. And the reason I'm saying that...
My question is, what must the commissioners look to see the collusion that you reference?
Because at that time, we have to cast our minds back to 2012. So during that whole period, there was a lot of media coverage. Major General Richard Mdluli, or Lieutenant General, Richard Mdluli, was in the media every single week, 2 or 3 times a week. This whole thing, as it was being played out in court, was all over the media. Now, by his own account, he spent 2 years sitting at home twiddling his thumbs during that period, while General Pierre went out and gave a complete pack of lies to the court, which was published. It was all over the media. I'm saying, if I know about something that's wrong and I keep quiet, I'm assisting in the cover-up. And that's the point I'm trying to make. And if you go through the documentation, if you go through the judgments, and you look at the timeline, there's absolutely nothing between his first statement in May 2012 and the Murphy judgment, still nothing. He only comes out with it for the first time 8 years later. Why keep quiet? Keeping quiet for 8 years, I'm saying, is acquiescing to crime.
I think, Mr. O'Sullivan, it's one thing to say by keeping quiet, he acquiesced in a lie that he knew about. So firstly, you have to establish he knew that General Piega in her affidavit has said this, and he chose to keep quiet. So you have to establish that fact first. And I don't know that you have said enough in your testimony that indicates he knew, as a matter of fact, not what you say. He was at home for 2 years. It was playing out in the media. He should have been aware of it. It seems to me that you would first have to establish that he knew, as a matter of fact, indisputable fact, that this was said in the affidavit, and knowing that he made the decision to keep quiet. That's one thing. But if to say that he colluded, and perhaps in fact he does collude if he does that on those facts, if he knew and he chose to keep quiet, he colludes by omission. That's the one form in which he could have colluded. The alternative formulation is he was deliberate. He was part of the cover-up. It's not a case of omission, but it was deliberate. So in a way, it was by commission, right? He knew this is happening, and he chose to be part of that lie. I don't know that beyond your, whether you can put it as high as that, and yet your statement here, where you say appears to have colluded in allowing the subs, I'm not sure that it is backed up by anything that you have said. We've gone through a number of instances where he has said and spoken, including up to the grievance that he laid against General Piega. And in all of that, I haven't seen, I must say, speaking for myself, that I don't see the positive and intentional act that you're seeking to convey in 1753, that he intentionally participated in a General Piega cover-up.
Okay, I hear what you're saying, Commissioner, and I'd like to draw your attention to what I say at paragraph 1.7.6. Because I'm saying there, in contrast, General Mkhwanazi claims in his affidavit to the State Capture Commission that he was completely unaware of the contents of General Piega's affidavit. I'm saying I find that claim in that affidavit unconvincing. And the reason I find it unconvincing is because he had made a grievance against her for being untruthful in her answering affidavit to the High Court. And I go on to say, General Mkhwanazi therefore knew that the allegation of an unlawful instruction to him was at the centre of the application. And the reply from General Piega would have to admit that central allegation if she was not going to perjure herself.
Thank you.
Sorry.
Yes.
Mr. O'Sullivan, you give two reasons for what you have just said now. You say, in contrast, General Mkhwanazi claims in his affidavit to the State Capture Commission that he was completely unaware of the contents of General Piega's affidavit because he was in his period of rest at home in KwaZulu-Natal at the time. I find this claim unconvincing because, and then comes the two reasons,
Yes.
or then come, not comes, the two reasons that you give.
Yes.
Even if I take a bit of time, I will read both. The first one is this. General Mkhwanazi was aware of the allegations in the FUL application because the founding affidavit in the agent application had been served on subs whilst he was acting national commissioner, and he had deposed to the initial answer in that application, but chose to sidestep the unlawful instruction allegation and simply not comment. General Mkhwanazi therefore knew that the allegation of an unlawful instruction to him was at the center of the application, and the reply from General Pierre would have to admit to that central allegation if she was not going to perjure herself. Let's focus on that reason and not overlap onto the second reason. Yes.
Of course, you can read different things into it.
Yeah.
The way I phrased it.
On what basis would you want to suggest that General Mkhwanazi would have known what General Pierre would say or not say in her answering affidavit on the Part B of the application, going so far as to talk about perjury and so on?
My argument, Commissioner, is very simple. I go to Minister Nshleko's presentation in 2015 to the Parliamentary Portfolio Committee on Police, where he talks about the grievance. And he didn't make the grievance in 2015, he made it earlier than that. So here he was making a grievance about the alleged perjury of General Pierre. But what he wasn't doing was saying it's perjury because this is what really happened. He just said she perjured herself.
But here you are talking about what General Mkhwanazi ought to have known, what General Pierre would say. Not what she had in fact said, what she would say in deposing to the Part B answering affidavit.
He would have backed him. He only knew about it after.
So those are two different things. What may have happened a couple of years later does not answer what General Mkhwanazi should have known with regard to what General Pierre would say in her Part B answering affidavit. That's where I am.
So, yes, Commissioner, but the point I'm making is he knew what the central allegation of the Freedom Under Law application was. He knew. The whole application was found on this allegation that he had received unlawful instructions.
But what's going to be deposed to is not his affidavit. And if nobody invites him to come depose to the affidavit as the person who actually knew what had happened, then on what basis can you fault him with regard to what the content of General Pierre's affidavit was going to be?
Let me give you an analogy, Commissioner.
Yes.
If you look at Section 34 of PRECA, the Prevention and Combating of Corrupt Activities Act, it makes it an offence for a person not to report a particular category of crime. We're talking here about the previous acting commissioner of police, who is now sitting at home twiddling his thumbs, watching all the media coverage. I cannot believe he wasn't able to see what was going on in the media. And instead of stepping up and saying, well, hang on a minute, this is not true, he kept quiet. And the point I'm making is he had ample opportunity to not keep quiet, and he didn't do so. And he was a policeman.
I know right at the beginning of this engagement, I said that we should not conflate the two reasons that you give, and I'm going to preach exactly what I had said to you. You see, the difficulty I have with what you have just said about not believing that he would not have become aware of what the media was saying. In your second reason, you actually accept the possibility that he might not have become aware of what was out there in the media. You go so far as to say that, but if he had himself not become aware, people close to him would surely have told him. So in answering my question with regard to the first reason, I do not think you can peg your answer on him having heard or seen or read what was out there in the media.
Well, of course.
Because then you are contradicting yourself.
No, of course. If the commission gives him the benefit of the doubt,
You first gave him the benefit of the doubt.
I don't necessarily, I'm saying I wasn't convinced by his argument,
Yes.
okay? And the reason I wasn't convinced of his 2020 affidavit was because in 2015, he was moaning and grievance about Commissioner Pieka lying under oath against him, about him, that he didn't say this, and therefore, he was never offered a confirmatory statement. At the end of the day, Commissioner, what it boils down to, from me as an evidence giver, is it's I suppose, 80% gut feeling. But if you look at the reality of it, there's no evidence between 2012, when he had an opportunity to come clean, when he made the first answering affidavit to the Part A, he had an opportunity to come clean and tell the truth. He kept quiet. And the first time we hear about it was at the State Capture Commission, and that comes out in his affidavit. And it really then is utilized at this commission. But what he doesn't do at this commission is said, by the way, I kept quiet about it for 8 years. I told the State Capture Commission, I just think it should have been a lot more transparent. If we are talking about a junior policeman, I can understand, but we are talking about a person who was the acting commissioner of police. He was in charge of running the police service, and he was the man, nobody else, him. He was the one that unlawfully put Richard Ndluli back to work, forcing civil society to bring urgent applications to get Richard Ndluli back out from his office. And I'm going to paint in my closing argument, or whatever you want to call it, the reality between that and what went on at the 6th of July media conference, because there are similarities here.
Yeah, those are related issues I will immediately accept, but you are dealing with something specific here, which is about why, and you keep repeating the words, he was sitting at home twiddling his fingers. I will not go so far as to say he was twiddling his fingers, but you repeatedly refer to the fact that he was sitting at home, and your point is more that he had all the time to basically anticipate whatever it is General Pieka would say about this, lest she perjure herself. That's the substance of the question. I accept the other issues that you've just referred to in response to my question are related, but they are not really what you are addressing in 1.7.6.2. So that is, my point is, this is somebody who is sitting at home under the circumstances that we all know, based on the testimony or the material before us. Now, on what basis must he insert himself and say, I'm lifting my hand, here I am, just in case the current incumbent, General Pieka, might perjure herself, I'm offering myself? Why should he have done that? Shouldn't those who were preparing the answer, the Part B answering affidavit, have been the ones who approach him specifically and say, you are the person best placed to answer this, therefore, please tell us what you know so that we file your affidavit as a confirmatory affidavit to what General Pieka is going to be saying?
Well, it's a tricky one, Commissioner. The reality of the situation is that during that period of time, President Zuma was running the country, or running government, and we had all these things going on. And I cannot say beyond reasonable doubt that he colluded. But what I can say is he would have known that in order for her answering affidavit to be truthful, she would have had to say that which he refused to say, which is that he got an instruction, according to his version of events later, from the commissioner, from the Minister of Police to reappoint General Ndluli. And let's give him the benefit of the doubt and say he wasn't listening to what's going on in the media. Let's just say that he was blind to all these things that were going on. But somehow he was able to make a complaint, a grievance. If I was in his shoes, I would have been beating a path to the door to say, hang on a minute, let's tell the truth here. But he couldn't. And the reason he couldn't was because it was still too short a period after the event where he had acted unlawfully by carrying out the instructions of the Minister of Police. But 8 years later, time has passed, and water has gone under the bridge. Now we can put it out there. I believe he should have put it out there a lot sooner.
Let's move on to the second reason, 1.7.6.3. I don't think we have much to say there because I already touched on it when we were dealing with the first one. But the point I will make in this regard is that doesn't your second reason become attenuated in the sense that you yourself already accept the possibility that he might not have seen, that is General Mkhwanazi, he might not have seen what was out there in the media?
Well, that possibility, you can say, exists there. But then I counter it by saying, even if he wasn't aware of the news coverage, it's inconceivable that none of his close colleagues in the police would have drawn General Pieka's denial to his attention. And the reality is, he became aware of it somehow because he laid a grievance.
That's speculation of the highest order. We are talking as at the time. I'm engaging you as at the time. That's speculation of the highest order.
It's hard to say.
Yes.
The time machine, I guess, would be needed.
Yes. Thank you. Thank you.
Thank you, Chair. Maybe for my understanding, can we go to page 384? 384 of the bundle, and that we are still in General Mkhwanazi's affidavit to the Commission, to the State Capture Commission.
384.
384.
Yep.
And he starts at paragraph 67 that on those dates, 17, 18, 19 of April 2012, they appeared before the Portfolio Committee. I'm interested in what's set out in paragraph 69, where he says, having presented, he concluded with the remarks, other powers decided on convictions, not just the SAPs. Here I was referring to where matters were taken out of control of the police. Is it that quotation that you say means where he's supposed to have said to Parliament that he acted at the behest of other powers?
Yeah.
Or is it a completely different engagement on that score?
My understanding, Commissioners, is that there he's talking about the criminal charges, not the disciplinary charges. So the criminal charges were not in his domain. They're in the domain of the NPA. And as we know, that was being mismanaged by advocates Mwebi and Jiba. So I opened, by the way, a criminal complaint against them for the mismanagement of that whole mess. So you had this situation where the National Prosecuting Authority under advocates, by the way, at that stage, Advocate Jiba was the acting NDPP. And then Advocate Mwebi, Lawrence Mwebi, was the head, the national head of commercial crime at the NPA. And they took an unlawful decision to withdraw the criminal charges, not only the charges pertaining to the kidnap and murder of his wife's ex-boyfriend, or whatever the case may be, but also the alleged fraud and corruption charges. They took those decisions unlawfully. And I believe that's what he's talking about here.
And that's the clarity I was seeking, whether what he states at paragraph 69. So you are saying when he says he stated to the to Parliament that other powers decided on convictions, not just the subs.
Yeah.
He was referring to the criminal case. It has got
Criminal
nothing
case,
to
but
do.
what he doesn't say, commissioners, is he doesn't say what he said about the disciplinary charges, because that's what he was questioned on in Parliament. And he said a higher authority, that's his words. And when they tried to drill down into that, he said he couldn't go into it.
I accept. I just needed your clarity on this, that quotation I read there, I should not misunderstand as his response to the issue of withdrawal of the disciplinary charges. I should not misunderstand that quotation to relate to that.
I believe this is not to do with the disciplinary charges. I believe this is to do with the criminal charges. He uses the word other powers decided on convictions, not just the police.
Can I then invite us to page 25, paragraph 1.7.10?
Uh-huh.
You conclude at this paragraph thus, and I quote, given General Mkwanazi's own collusion in an illegal process of political interference designed to keep Ndluli in charge of the Division of Crime Intelligence and its regularly stolen secret funds, it is difficult to take seriously his complaints of political interference.
Yep.
Okay, and you go on. Do I understand you correctly that you suggest General Mkwanazi colluded in retaining General Ndluli in the Division of Crime Intelligence to facilitate the stealing of secret funds? Is that, am I understanding you correctly or I'm misunderstanding you wholly?
Sorry, I'm not quite.
I was saying my interpretation of what you say there, I wanted to test whether I'm correct or whether I'm misunderstanding.
So what I'm saying is there's similarities.
Yes.
The similarities in 2012 are the same as the similarities in 2025 in July. In 2012, it was to protect the head of crime intelligence, which was Lieutenant General Ndluli. In 2025 in July, it's to protect, I'm saying, and that will be the next bit that I come on to, that it was to protect crime intelligence.
Oh, so
those are the similarities.
So a protection of General Ndluli.
Ndluli, I'm saying
2012, you say, was by General Mkwanazi himself.
yes. I'm saying that in 2011/12, he was protecting one general in crime intelligence, and in 2025, he's protecting 5 generals in crime intelligence.
Okay. Now you've tendered this affidavit, so I'm sure you are familiar to some extent with it. From paragraph 9 of that affidavit, General Mkwanazi makes the distinction or seeks to.
So what page?
Paragraph 9, I'll tell you the exact page now. 349, under the heading the Ndluli matter.
This is one of the annexes.
Yeah, your annexures, yes. We are still
Page-
with 349.
Page 349.
349, yes.
Yep, got it.
And at paragraph 8, he makes the point that when he was appointed, General Ndluli was the Divisional Commissioner of Crime Intelligence.
Yep.
At 9, he points out that by then he had, as he joined as acting National Commissioner, General Ndluli had already been on suspension, having been suspended on 29th April 2021.
Correct.
And that suspension related to the alleged murder case.
Uh-huh.
And at 350, he continues that at paragraph 10, on establishing that Lieutenant General Ndluli had not been suspended on the fraud and corruption charges, which he introduces in the paragraph above, he instructed Lieutenant General Stander, the Deputy National Commissioner of Human Resources, to initiate steps to implement disciplinary charges against Lieutenant Ndluli in this regard.
Uh-huh.
Then at paragraph 11, he speaks about General Nebeam, which we can skip. And then at paragraph 12, he says, as part of my briefing on this matter, I was advised that Major General Solil Lazarus, the Chief Financial Officer of the Secret Service account of CI, had already been suspended and charged criminally for fraud and corruption. He continues at 13, I then decided to instruct Lieutenant General Stander to appoint an outside person to assess the available evidence to determine whether it implicated General Mdluli and then to advise me on the way forward. These events took place roughly towards the end of 2011. I attached marked NM1 a copy of the report obtained by Lieutenant General Stander pursuant to my instructions. He then says at paragraph 15, pursuant to this report, disciplinary charges were brought against Lieutenant General Mdluli. This is now for the fraud. Do you accept the facts as set out by General Mkhwanazi in this affidavit, or do you have reason to doubt
In there,
their veracity?
I can't contradict them.
Okay, now in light of that, if you then are forced to accept, is it fair to suggest that he took steps and colluded in a process that will protect General Mdluli and enable the further looting of secret funds? Is that a fair conclusion? If you accept the facts as stated here.
If what he says here is true, then it means he's doing his job. But then along came the minister who said, cut all this up, drop the charges, put him back to work. And he did that. So he may have started off on that course. I guess the best person to ask is him.
Okay.
Can I ask a question, because you introduced the involvement of the minister?
Sorry?
You introduced the involvement of the minister.
Yes.
2 months after the suspension was lifted, so on the same day that FUL launched the urgent application, you are aware that General Mkhwanazi did suspend General Mdluli again.
10 days later. The Freedom Under Law case was launched
Yes.
on the 15th of May.
Yes.
General Mkhwanazi General Mkhwanazi resuspended General Mdluli on the 25th of May.
Yeah. Don't confuse the date when he was charged with the date when he was suspended. I had understood, having read the judgment, both the High Court judgment and the Supreme Court of Appeal judgment.
He was resuspended on the 25th of May.
I'm looking at paragraph 95 of the judgment. You may be right, because it says the application was launched on the 15th of May 2013. I think that's a typo in the judgment. It's 2012, right?
So
I'm on page 409.
409.
Yeah.
Let me just go to it.
409?
Yep.
I think this may be a typo in the judgment. That should be 2012, right?
The wording of the paragraph would suggest so.
Yeah.
Which paragraph? Sorry?
Paragraph 95.
95.
Yes.
Uh-huh.
You may be correct. So I think there's a typo there with the date. But your point is that he only resuspended him after the urgent application was launched.
After the Freedom Under Law application was launched, he realized, there's trouble coming.
Yeah.
But contemporaneous with the launching of the Freedom Under Law application, Advocate Chowki was the Director of Public Prosecutions in Johannesburg, and he had given instructions for an inquest into the murder of, or the death of Opa Ramakgobi. So what happened was, during that inquest, in the week after the Freedom Under Law application was launched, and while General Mkunazi was having to deal with his answering affidavit, revelations were coming out at the inquest about the conduct and the kidnapping and the beating up of Opa Ramakgobi, allegedly by, in fact, he was convicted by it later.
Mr. O'Sullivan, I want to stick to the theme of the question by Advocate Sillo. So my question in essence is, what do you make then of the fact that during the May period, he did suspend General Mdluli again, and in fact, he was charged?
Well, he didn't really have much of a choice because he's got this application landed on his desk on the 15th of May. So 10 days later, while he's doing his affidavit to respond to this application, this urgent application, he resuspends him. And I'm saying he was in a corner. He had no choice. He had to do it.
But
Mr. O'Sullivan, I think you are aware in this affidavit here, you've got where he describes where he describes the steps that he took, and that includes engagement with the Inspector General, and the Inspector General at some point instructing that he should lift the suspension and have Mr. Mdluli come back to work, and he didn't agree with that. So you are aware of the steps that he took.
Yep.
But for that he acted on ultimately he acts because the minister is now involved in the matter. You surely couldn't fairly say, disregard everything else that he has done and say, because he followed the minister's instruction and put it as high as that was action he acted to protect Mdluli, who for purpose of plundering the secret fund. You can't. I mean, there's a logic in it. There's a disconnect in that you seem to, in fact, not you seem to, you do as a matter, as you testify that you disregard all the efforts that he took to discipline General Mdluli. You disregard that, and then you say, well, he followed the minister's instruction ultimately. The minister instructed him, and by following the minister's instruction, he therefore was in fact protecting Mdluli to enable him to continue to plunder the secret fund. I don't understand that logic or that reasoning, because it seems to be quite selective. From where I'm sitting, you seem to be selective in refusing to acknowledge the steps that he took, but also to acknowledge that, in fact, when he did withdraw the uplift, rather, the suspension, it was at the instruction of the minister. You can criticize him for following the minister, just like the court did, right? That he's got the discretion, he's got the power. He should have insisted to exercise his power. Well, he didn't. He followed the minister's instruction. How that translate so easily, in your view, to it being a deliberate decision on his part to protect crime intelligence general for purpose of plundering the secret fund, and then you say in exactly the same way that is done in 2025. I'm battling to see the connect that you seek to make in what seems to be disconnected.
I don't consider that I've disconnected. If I look at it, what happened at the time? He's only given his version of events 8 years later. Nowhere at the time does he explain all these events. He waits 8 years. He could have said in his answering affidavit to the court, he could have outlined these things then. He didn't. He kept quiet about it. He only comes out with it 8 years later. Now, if one has to give some real thought to this and think out of the box, one has to consider the following. He was a senior police official. He was a major general in the police, and he was aged 38. There were probably at least 40 generals in the police.
So, Mr. O'Sullivan, we're not discussing that now, sorry.
Okay.
It's late in the day. We are not
All right.
discussing what you have addressed in your statement. Our question is really, the theme now is a very, it's a direct theme. It doesn't require you to speak about his promotion that you obviously were not happy about. It is simply this, that you unless you say everything that he says I did, or the steps that he took to discipline, to suspend, unless you say all of that is a lie, right? And I didn't understand you to be saying all of that which he says he did is a lie. Unless you're saying that it's a lie, I don't see how you can fairly say today, knowing what you know. Remember, when you draft this affidavit for the commission, you know this history, what he alleges he has done. Knowing all of that, and then you in June, as we sit here, you say, well, that he did not say it's the minister that instructed him, that he did not contradict General Pierre in an affidavit in court. Those two things are evidence that he in fact was colluding. He made the decision to collude to keep General Mdluli in place so that he can continue to plunder the secret fund in the same way that he's doing in 2025. I don't see how you get there. It seems forced to say, well, that's what he was doing in 2015 or whatever year it is.
Yep.
And then you say, well, it repeats, in fact, in 25.
I hear what you're saying, Commissioner, and my point is quite simple.
Yes.
But if the content of his affidavit in 2020 had been included in the content of his affidavit in 2012, I would absolutely agree with you. But it wasn't. The whole thing was kept quiet for 8 years. And I believe it could have been put out into the open 8 years earlier. And who knows what effect it would have had on the police. It might have changed the future.
Thank you.
I think we've traversed this already, but we did clarify that the freedom under law application was brought in two parts. The part A was an urgent interdict. Is my recollection correct?
Correct.
That is the part A.
Part A, the order was granted.
Yes, I'm aware.
Yeah.
My issue is General Mkwanazi deposed to an affidavit in regard to the relief sought in part A. So it's not the main application. The main application is in part B. The review application.
Yeah,
right?
I agree 100%. The main application was part B.
Yes. So if we agree on that score, are you suggesting that all these facts that he has set out in the affidavit deposed to before the State Capture Commission, he should have set them out in his answering affidavit to the part A relief?
Because the central theme of freedom under law's application was his alleged receipt of instructions from a higher authority. And on that, he kept quiet. So I'm saying that would have been and by the way, he didn't have to go into all the detail he's gone into with the Sondo Commission, but what he could have done was take those crisp elements and say, listen here, this is what happened. It wasn't just me, it was the OIG and it was the minister, and then put it on the table. But no, the whole thing was hushed up for 8 years.
Just then, I guess as a final point on this, page 367, we're still in the affidavit, paragraph 24. He states in that paragraph that during this period, of course, this is after a whole long narrative about what was happening and the IGI's report and what steps he took. So then he says, during this period, I met with Lieutenant General Mdluli. I informed him that I had written to the IGI and had received a response from her regarding the disciplinary matter against him, but was awaiting her response regarding the criminal case against him. I gave the same advice to Minister Mtetwa. At paragraph 25, he notes, I disagreed with the IGI's view that Lieutenant General Mdluli should return to work. She had not yet read the criminal case docket or expressed an opinion thereon, and I felt that she ought first to do so before he could be reinstated. I telephoned Advocate Khadebe to inform her that I would not be lifting General Mdluli's suspension until she has perused the criminal case docket, as this might influence her initial decision regarding the disciplinary matter against him. I was also aware that Advocate J. Govender from IGI was an experienced advocate and a former prosecutor, so I had faith that she would assist the IGI in making an informed decision on the status of the criminal case. Now, I was just concluding this conversation we're having, that these are some of the steps he states he took to resist the upliftment of General Mdluli's suspension. Now, my question is, do you take issue with the veracity of what he claims here?
The only issue I take with this is what I said earlier. This belonged in his answering affidavit.
Okay.
He
Not
should
so
have
much
taken the
that-
court into his confidence and explained to the court exactly what went on in having, and then it would have resolved not only Part A, but there would have been no need for Part B, because actually Part B was fought hammer, tooth and nail by the police, and it was fought out in the Supreme Court of Appeal. So there would have been no need for all of that if he'd have taken the court into his confidence in May 2012.
Noted, thank you.
Advocate Sidlo, Mr. O'Sullivan, I understand your criticism, and if one reads the SCA judgment, it appears to be the same criticism that one finds at page 470. 470 of the annexures or exhibits. So if you start at 469, paragraph 49, the court says the factual basis for the challenge by FUL is that it relied on statements made by then acting commissioner, General Mkhwanazi, in Parliament, that he was instructed by authorities beyond him to withdraw the disciplinary charges and reinstate Mdluli in his office. And then FUL added that in doing so, Mkhwanazi had failed to make an independent decision, which rendered his actions reviewable. So that was the point about the review.
Yep.
And then the court says, this is now SCA. Though Mkhwanazi filed an answering affidavit in the interim interdict proceedings in Part A of the notice of motion, he did not deal with these allegations.
Exactly
so this
the
is
point.
your point.
Yeah.
And
Exactly
then
the point.
what the court then concludes, we can ignore the rest of that because it relates to General Pierre. In paragraph 50, the second last sentence, the court says, let's start at the fifth line where the court says, I do not believe this finding can be faulted. Moreover, after all is said and done, neither Mkhwanazi nor Pierre gave any reasons for the impugned decision. And then the inevitable conclusion is that the decisions were either dictated to by Mkhwanazi or were taken for no reason at all.
Yep.
And so the court has made a decision that in the absence of an explanation, we can conclude that they were dictated to by somebody
Yes,
else.
and Commissioner, if I can say, what they've done in the Supreme Court of Appeal is they've stuck the evidence of Pierre, because she stated under oath that this is actually what really happened. And to prove it, I'm going to come with a confirmatory affidavit from General Mkhwanazi. And since there was no confirmatory affidavits, they struck that evidence. They said that's immaterial. Therefore, they go back to game one, which was the answering affidavit submitted by General Mkhwanazi, where he just didn't deal with the issue.
So the point I'm making is because we were not getting anywhere, and I had understood that your criticism, you were taking it from the judgment. Although you added your own flavor to it, I must point that out, that you
Yes.
added your own flavor to it. But the substance of what the SCA found is that because he did not answer the specific allegations made by FUL,
Yep.
the inevitable conclusion is that he was dictated to by
Correct.
those
Correct.
above him.
Yep.
And we leave it there. And I think when General Mkhwanazi comes here the second time, we may then give him the opportunity to respond to your criticism of his conduct. And that's the best way of dealing with it.
I agree.
Thank you, Commissioner Khumalo. You conclude then at paragraph 1.7.10 at page 25 by stating, for example, in 2011-2012, General Mkhwanazi's conduct was intended to unlawfully protect Crime Intelligence Divisional Head, much the same as his conduct in 2025 is intended to protect the Criminal Intelligence Divisional Head and those under him. That then leads you to your next topic at page 26. At paragraph 1.8, and I think we should make a correction there. It reads July 2026 media conference. It should be 2025. The heading.
Yes,
we correct
1.8.2.
At 1.8, the main heading, it reads July 2026 media conference. That should read July 2025.
Yes, thank you.
Then you say, in this part of your statement, you are more or less posing a question to the commissioners.
Correct.
And you are not testifying or advancing any factual basis or suggesting that the media conference was intended to protect criminals. That's not your suggestion.
I'm not.
You are posing a question?
It's not a statement, it's a question.
Okay.
And what I'm asking the commissioners to do is to have an open mind and ask yourselves the question, was that media conference a smokescreen? That's what I'm asking you to do. And in order to guide your thinking on that, I've given my own ideas here. And my ideas are quite simple. I've made it clear that for years and years and years, the epicenter of crime in the police service is the Crime Intelligence Division. It's the epicenter. Everything that goes wrong in the police, it's the Crime Intelligence Division. And why? Because we have a so-called Secret Services account, which is so secret, nobody can know how the money's spent, which is great. Because if you want some money to do other things with, you can do it. And nobody can ask you any questions. No Auditor General has ever given a clean report on the Crime Intelligence Secret Service account. And if one looks at the growth of that fund, by the way, you can pick up from the police budgets, the fund itself, but you can't see how it's spent. And in 2012, when General Mkhwanazi was the acting Commissioner of Police, the budget for the Secret Service account was 98 million rand per annum. In 2024, it stood at 600 million rand per annum, which is an increase of 512%, which is 5 times the rate of inflation over that same period. But what we don't have is we don't have a concomitant decrease in crime. What we do have, if you look at the last 14 years, is we have successive heads of crime intelligence being arrested and sent to jail for stealing from the Secret Service account. It's just a manna from heaven. It's gift. And there needs to be a lot of control, much better control over that. And I talk about here, when I ask the question, was it a smoke screen? I ask the question, I name 5 generals and 2 brigadiers who were arrested in June 2025. They were arrested on the 26th of June. It's no coincidence. In my annexes, I have taken that media briefing of General Mkhwanazi and I've had it transcribed. The transcription is there. And if you look at the theme of the transcription and start looking at the mentioning of crime intelligence, it starts to conjure in your mind, was this a whole smokescreen to protect all of these people in crime intelligence. And when you think about it, and I ask you to keep an open mind, if you look at it, there has to be an answer there somewhere. It cannot be right that this is all linked. By the way, on the 1st of July, I had my attorneys, the attorneys of Forensics for Justice, I had them send a very strong letter to Commissioner Masemola. And the letter is very strongly worded. And it talks about the accused persons, which I refer to in my affidavit as a crime intelligence 7. And in that letter, we're demanding that these people are urgently suspended because they've all been charged with corruption. And according to General Mkunazi, it's not corruption, it's an HR matter. I don't agree with that. It's corruption. So we have this situation where they're charged with corruption. We send a letter through demanding that they be suspended. An hour later, or 2 hours later, we get a short reply back from General Masemola, which is on page 505 of my evidence bundle, which effectively says, I'll do what has to be done. I'll comply with the law. Not one of them has been suspended. Not one. To this very day, not one of them has been suspended. And by the way, some of them have been charged more than once because General Lushaba, who's the CFO, he's in charge of the Secret Service account. He was also charged with losing his laptop computer and a firearm and instructing members under his command to go out and get his laptop and firearm back, and then to doctor the docket that he opened. And when he opened the docket, he said that somebody came in through his window and stole his firearm, his state-issued firearm, and they stole his laptop. But it actually turned out that he'd invited a lady into his premises, and they had a few drinks, and he fell asleep. And she made off with his money, his firearm, and his laptop. He got other police officials at the rank of colonel to go and get his laptop and firearm back, which they did. He's charged for that. He was arrested for it and charged. And what they did, they went and got his laptop and firearm back. But now we had a problem because he'd opened the docket at the police station where he said somebody had climbed in through his open window. So he got those two colonels to go to that police station and get hold of the investigating officer on the case that he'd opened and remove the papers from that docket and replace them with fake papers. So that's the sort of thing that's going on in crime. That's the chief finance officer of crime intelligence. And when you look at all these things going on, and then you analyze, commissioners, the transcription, because nobody's produced the transcription before now. I've produced it. I had it produced within days of his media conference, and it's there at pages 510 to 536. And what's interesting is on page 533. On page 533, he doesn't mention my name. General Mkunazi says the following. That's why there's a call in public from a person that I will not necessarily mention his name, that the National Commissioner must bypass the disciplinary regulations of the service, must simply suspend these people because it's inaudible. Why is that call? It's a call that is putting more pressure to make sure the country, hence the handing over to the criminal syndicate. So because I've called for the suspension of these 5 generals and 2 brigadiers, General Mkunazi is accusing me of handing the country over to the crime syndicate. In fact, I'm trying to stop this crime syndicate that's active in crime intelligence from carrying on with their crimes.
Mr. Sullivan, can I ask you one question? You say the press conference of 6 July 2025 was a smokescreen.
Was it? It's a question.
Yeah. So let's assume that it was.
Pardon me?
I'm saying let's assume for the purposes of my engagement with you that it was a smokescreen.
Yeah.
Does it mean that the allegations made that day are not true and should not be investigated? Because that's what this commission has been established to do.
Absolutely.
It is to investigate, amongst others, the allegations that were made by General Mkhwanazi on the day. Now, say his motive, for argument's sake, say his motive was to protect the Crime Intelligence 7.
Yeah.
And that was his reason for this press conference. Does that mean the allegations he made are not true and should not be investigated?
Absolutely not. In fact, if you look at me having gone on record, on the 6th of July in the evening, I did a media call. The media contacted me about this whole media conference of his. And the first thing I said was there needs to be a judicial commission of inquiry. I made the point, and I've repeatedly made the point, that the lack of attention by the State Capture Commission to the criminal justice system has resulted in where we are today. And I have absolutely no doubt that a lot of good will come out of the allegations he's made. But were they made for the right reason? That's the question I'm asking. And I don't believe they were. And if you look at the transcript, it starts to come out what actually the purpose of that media conference was. And I don't believe it was just about Minister Mchunu and these various parties, what's his name, Kat Malala, and all these other people. I don't believe it was about that. And the reason I've given in my briefing here today is that I start off by saying this isn't the first time that we've had criminals penetrating the criminal justice system. It's been going on for years and years. Even during apartheid, it was still going on. So this is not new. But if any good comes out of it, fabulous. But what I'm saying is we need to keep an open mind as to the motive. And that's all I'm requesting.
Is the motive a question that's within our remit, though?
Is the motive, sorry?
Is it a question that's within our remit? Must we answer that question?
If one looks at your, if you look at your...
So does that question fall within our terms of reference?
Yes, if you look at your terms of reference,
yes,
it doesn't go there. However, if you apply, as your colleague did earlier, this novus actus interveniens, what if he didn't call that media conference? Would we be sitting here today? The answer is no. So a sequence of events has taken place. And all I'm saying is not everything is what it's been painted out to be. And I've requested the commissioners to keep an open mind. I keep an open mind on these issues. Of course, I would like to persuade you this way or that way. But the reality is, I would never like to persuade you of something that's not right.
we should keep an open mind on matters that fall within our terms of reference.
Exactly.
So that's why I'm engaging you on whether this is something that falls within the terms.
Then you're left with the question.
Especially bear in mind that you have said a lot of good has come out of this process, and probably most of it does indeed fall within our terms of reference. So the issue is, all of that, or all of those issues, because we are yet to submit a final report, all of the issues that have arisen are issues that we must keep an open mind on, except those perhaps that are clear and on which everybody has already said something. That is, even those that are implicated.
Of course.
Perhaps on those we may make, or rather have sort of final views on such matters, but otherwise we keep an open mind. But that relates to matters that fall within our terms of reference. So you keep saying, you're asking us to keep an open mind. If what you are raising, insofar as the motive is concerned, does not fall within the terms of reference, the issue of us keeping an open mind does not arise at all.
Oh.
If you accept that the question of the motive does not fall within our terms of reference, but I'm engaging you on whether it does, and I think you've accepted that it does not.
It's chicken and egg, isn't it? Because if the motive was to create a smoke screen, then it possibly does fall within your terms of reference, because you need to know what was that smoke screen all about. And then you start asking other questions. So I prefer myself to be the bringer of information, not the decider of facts. But I brought the information to this commission because I've spent the last 36 years of my life trying to make this a better country to live in for all people in South Africa. And that's why when I saw what was going on, I thought, I need to throw my 10 cents into the mixture as well, especially since I've been named by the protagonist. When General Nku got up and blamed me, I had nothing to do with this Cat Matlala and these drug cartels and all the rest of it. I had no knowledge of what was going on until I heard about it in the media. But for him to name me, why was he naming me? And I can tell you the reason why. Because I didn't write, I got my attorneys to write a letter to General Masemola and demand that these 5 generals and 2 brigadiers be suspended. That's why I was named.
I would understand the smokescreen point better if it does not go beyond saying this was a smokescreen that was calculated to shield these generals from criminality that they are otherwise involved in. So we don't really get into, was it indeed a smokescreen? No, that's not before
I
us.
understand.
That's not before us.
I agree with you. I agree with you that your terms of reference do not ask you to consider whether it was a smokescreen.
Yeah. So the criminality itself would then have to be something that does indeed fall within our terms of reference. The criminality shielded by the smokescreen.
2 of the same 5 generals apparently are going to be arrested again. I have no knowledge of that, only what I've seen in the media. Hopefully tomorrow will be a peaceful day, and then whatever has to happen will happen. But I do believe that it will all unravel. It normally does.